Hi everyone, thank you so much for joining us for today's webinar, which will cover the Building Belonging Report, the outcomes of the review of Queensland's Anti-Discrimination Act. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, there are the Turrbal and the Yagara people. I wish to pay my deep respect to elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and a few interstate friends as well, I'd like to pay my respects to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are joining us today. I'm really pleased to welcome today Queensland Human Rights Commissioner Scott McDougall and Heather Corkill from the Queensland Human Rights Commission, who'll be presenting a summary of the key recommendations in the Building Belonging Report, including the introduction of a positive duty to reorient the system from reactive to proactive, which is a major change. So I'll hand over to Scott and Heather in just a moment, but before I do that, just some quick housekeeping. So today's webinar is being recorded and I'll have that recording available for you to download this afternoon. The PowerPoints have been uploaded to the GoToWebinar control panel for you to download, and I've also emailed them out to everyone who registered about half an hour ago. I really encourage you to ask questions. We will hopefully have some time at the end of the presentation for questions, and some have already come through, so those will be dealt with as well. Please feel free to type those questions into the question box as you think of them though. We do also have 3 polls today, so please pop your answers in when those polls appear on the screen. So I'll now hand over to Scott to kick us off. Thanks very much.
Thanks very much, Carly. My name's Scott McDougall. I'm the Human Rights Commissioner, and many of you would hopefully remember me from my days at Caxton Legal Centre. It's great to be back with amongst the community legal sector, even though I can't see you. It'd be really nice to be in a room with you. I can see that there's 49 people in the webinar, which is fantastic to see the level of interest in this area of law, which is obviously really important for community legal centres. So I'm not going to talk for very long. Heather Corkill, our Senior Policy Officer, is going to take you through the content of the report, but I'll hang around for the end to deal with some of the questions. And I thought I would just give a bit of background to how we came to do the report and our approach to it. So early last year, the Attorney General surprised me by asking the Commission to undertake a review of the Anti-Discrimination Act. And as that is obviously our own governing legislation, it's fairly unusual for an organisation to be asked to review their own governing legislation. And I guess for that reason, we were particularly mindful about creating a very robust methodology. And so the first thing we did was establish a reference group, and I'm very grateful to CLCQ for joining that reference group to guide some of the early planning around how we would conduct the review. We then established a review team led by Jane Basie, with Heather Corkill again playing a key role. And we then embarked on a series of preliminary conversations. I think we had about 60 meetings with targeted stakeholders, many of whom were in fact community legal centres. And those initial consultations were really very valuable in helping us prepare a discussion paper, which we released in November last year. It was also, I'd like to give credit to the Alliance of Queensland Lawyers and Advocates, who prepared a 10-point plan very early on in the piece, and obviously we took that into account as we prepared the discussion paper as well. As far as 10-point plans go, is much better than the one that John Howard put out in 1996, which many of you would probably be too young to remember. The other thing that I'd like to acknowledge is the number of submissions that we received broadly, not just from the CLC sector, but throughout Queensland. Over 130 responses to the discussion paper. A lot of the submissions were of really high quality, and I was really pleased that we were able to get them up on our website so that people can see them. And we also had a great response to our online survey. Obviously, a huge amount of research and analysis went into the report. If you take the time to read the 400 odd pages of the report, you'll see the amount of work that's gone into it. And again, I'd like to thank the person I'm now going to hand over to, Heather, for who deserves a lion's share of the credit for this report. Thank you, Heather.
Thanks so much, everyone. So, and thanks for the introduction. So, my role is a Senior Policy Officer at the Commission, and as Scott's mentioned, we worked in a very small team in a pretty short period of 14 months to deliver this report, and it is around 400 pages. We do, to illustrate, this is a copy of the report that we also do have available. So, by request, you can order a copy of the written copy of the report as well, if you like, after today's session. So because we've got such limited time to summarise the report of this length, what I've focused on in the presentation today is some of the key reforms, the key concepts such as the meaning of discrimination, a little bit about the complaints process, a fair bit of focus on positive duty. We will briefly have time to overview the attributes, including new attributes that we've recommended, and a very short amount of time to talk about our methodology and what exceptions to discrimination we've suggested are changed. So thanks for any questions. We've had a great deal of interest and a whole lot of questions on notice already, so we will do our best to cover that and more today. But if you can just hold, we'll hold on to your questions at the end and sort of see how we go. So to launch right into it then, just wanted to sort of see people's familiarity with the Anti-Discrimination Act with a brief poll here. So Carly, I'll get you to launch that one, but the question is simply, how familiar are you with the Anti-Discrimination Act? So it's not at all familiar, quite familiar, reasonably familiar, or very familiar.
Great, that poll should be up now, so please pop your answers in. I'll give you another 10 seconds to do that. Okay, great. I'll just close that poll up and share those responses, which hopefully you can see on the screen now.
Yeah, and I'm seeing quite a reasonable degree of familiarity here. So we had 29% were quite familiar, 38% were reasonably familiar. So that is helpful because, as we know, those who already sort of work with the legislation, it can be complicated to even grasp the sort of basic concepts within it. So I won't spend a lot of time talking you through what's in the existing Anti-Discrimination Act, except to sort of briefly say that it's been there for the last 30 years to protect people from a number of contraventions in areas of public life, and that's including unlawful discrimination, sexual harassment, vilification, victimisation, and unlawful request for information. And in brief, discrimination is only unlawful if it occurs on the basis of a protected attribute, and we will talk a bit more about attributes towards the end of the presentation, and in an area of public life, for example, education, work, or receiving goods and services. A brief note that vilification has been the subject of a separate review by a parliamentary inquiry process, and they have reported their findings, and there has been a government response on that. So we're anticipating that those recommendations will join up with our recommendations to create one bill, hopefully. So if you're interested in vilification, that is a separate area to look at as well. Okay, so the Anti-Discrimination Act, oh, I'm sorry, just before we start that, I'm just going to turn my camera off just to save any bandwidth. So you won't see me again for now, but just the presentation. Okay, so the Anti-Discrimination Act has played a central role in protecting and promoting equality, but hasn't had a thorough review in 30 years until the time that we were asked to undertake this review. So in these 30 years, society had shifted in many ways. So, you know, to give you an idea of what was happening in 1991, homosexuality was only decriminalised that year. And in the same year, the Mabo decision came just a year later, in 1992. So it gives you the idea of the significance of the shift between then and now. So Queensland's undergone many significant societal and attitudinal changes in these 3 decades. We're more diverse in terms of our race and religion. Terminology has changed and our language has shifted in many ways, and our family structures and relationships look different. So we thought it was vital for our discrimination laws to keep pace with community attitudes and expectations, and this review was an excellent opportunity to make sure that that happens. In terms of the key issues we identified early on, first of them was the limitations of the reactive system as it is now. So while as a complaints-based system, it can be of value to individuals in resolving single instances of discrimination, but seem to be having a limited role in addressing more complex and systemic forms of discrimination. Secondly, we found that the law had evolved in a way that wasn't responding effectively to the issues that needed to be addressed. For example, it had become complex, it was hard to understand, and there's also inconsistencies with federal laws covering the same subject matter. Thirdly, we found that there were gaps in protection, either created by attributes not being recognised or some definitions excluding parts of the community that experience discrimination, or exceptions to discrimination, or exemptions as they're called now, that did not achieve the right balance in providing protection from discrimination while allowing for some differential treatment where there's a genuine important reason for that. So the key reforms were addressing those 3 issues. So the first is shifting the focus to prevention of discrimination and sexual harassment before it happens, rather than solely relying on complaints. The second key reform is extending protections to everyone who needs them. And thirdly, making the law easier to understand and apply by modernising language and definitions, streamlining the complaints process, and making it more flexible and efficient overall. So in relation to discrimination, I'll cover off on some of these aspects in a bit more detail. So some of the key recommendations we made in relation to concepts in the Act, and I'll describe the current approach and then what we recommended should change. So in relation to direct discrimination, the current test is that it's based on less favourable treatment compared with another person in the same or similar circumstances, and discrimination must also be a substantial reason for the treatment. We recommend a change to an unfavourable treatment test because of attributes, an attribute or attributes, I should say. We recommend that comparator is removed from the test, and that we shift from a substantial reason to the treatment to simply being one of the reasons. And so based on the case law and in submissions to the review, we determined that the key definitions of both direct and indirect had become quite bogged down in technical problems that were diluting the effectiveness of the law. Our terms of reference specifically asked us to look into alternatives to the approach that includes a comparator. And at the moment where there isn't a real comparator to less favourable treatment, and there isn't often one, courts and tribunals have been puzzling over who is the correct hypothetical comparator in the same or similar circumstances. We heard from stakeholders that the concept of the comparator was creating numerous challenges, that it was too technical, hard to understand and apply for parties, was becoming increasingly complex when a person's arguing they were discriminated against because of a characteristic of an attribute, that the hypothetical comparator was an official and contrived exercise, and finally that this was actually placing the emphasis in the wrong place. So working out who the comparator may be was taking the focus away from the real question to be asked, which was there something unfair that was happening to a person because of their protected attribute? So not all legal stakeholders agreed that the comparator should go, and some considered that the concept of less favourable as opposed to unfavourable treatment was fundamental in determining whether discrimination had occurred, and was helping courts and tribunals to actually determine whether there was a sufficient nexus between the detrimental treatment and an attribute. However, through our research, we came to understand that removing the comparator element as a mandatory part of the test wouldn't necessarily remove that comparative analysis. That may still take place, but it would just become simply one tool to identify the reason for the treatment. And that's reflected in the Racial Discrimination Act, where there is no comparator as part of the legal test under Section 9 of that Act. And while the Federal Court has determined it does not need to be constrained by a complex hypothetical structure and other anti-discrimination laws, where helpful, it will still consider a comparative analysis where it's helpful to identify the reasons for the treatment. Overall, there was widespread support for simplifying the legal tests as to whether or not something is discrimination, and we considered various options available in Australia and overseas, including the UK, and determined the best option was to move to the approach of the ACT and Victoria, which have the unfavourable treatment test. There's been evaluations of the law by an academic researcher, and those indicated that changes have been overall positive. Simplifying the law has led to more certain and predictable outcomes for all parties, and was producing more accessible and less technical case law. Further, we also heard from stakeholders that needing to prove that there was a substantial reason, that discriminatory reason was a substantial reason was too high a burden on complainants. We heard that asking courts to untangle multiple causes of discrimination can be very complex, and most jurisdictions had already moved away from this approach and instead only required that discrimination is one of the reasons. So consistent also with federal laws, we recommend a change to that approach instead of a substantial reason. Secondly, in relation to indirect discrimination, we heard similar things about the complexity and technical way in which the law was framed, and this was distracting from the main issues. So people told us that sometimes the terminology cannot comply with the term, doesn't cover discriminatory treatment, whereas clearly putting someone at a disadvantage because of their attribute. And while courts have taken a pragmatic approach to the threshold for cannot comply, this wasn't always understood by duty holders and unrepresented parties. So the current approach is that a term is imposed, which could be also a requirement or condition or practice, that a person is unable to comply with. A higher proportion of people without an attribute could comply. So the second part that was seemed to be complicated was this higher proportion without attribute can comply. So we heard that presenting statistical evidence to determine the pool of people who cannot comply also had similar challenges to the comparator for direct discrimination, and that finding this evidence for many attributes was considered to be impractical or even impossible. We heard from stakeholders that the importance, that there was a real importance of retaining reasonableness aspect of the test. So I've obviously failed to put that into the slide here, but it does require that it's an unreasonable term, requirement, condition, or practice. And so although some suggested a more human rights-based or proportionality approach to determining reasonableness, we took into account a number of things and considered that moving to a test like completely aligned with the Human Rights Act may become even more complicated. So what we recommend overall is an approach that also would align Queensland with the ACT and Victoria, and that's a disadvantage test. That would simplify the test and remove the cannot comply and the higher proportion aspects, and would definitely retain reasonableness. And so the test would look something like this. So a person imposes a condition, requirement, or practice which has or is likely to have the effect of disadvantaging the other person on the basis of their attribute or attributes, and the term is not reasonable. And to consider, there was a variety of reasonableness tests through throughout different states and territories and the Commonwealth. We thought the best one to follow was Victoria, which is actually an expanded list compared to what we currently have. Or it's already a non-exhaustive list in Queensland for what is reasonable, but we thought there could be better guidance on whether a condition, practice or requirement is reasonable. So it would be reframed to focus more on equity principles rather than only on the financial factors that may impact on a respondent. And we also, the other benefit is that it also includes an aspect of proportionality and consideration of whether reasonably available alternatives were considered at the time. The next topic is combined grounds. So we heard consistently through our initial consultations and also in submissions to the review that the Act wasn't adequate in the way it recognises and addresses intersectional discrimination. That is, discrimination because of a combined effect of more than one attribute. So at the moment, the language of the Act presumes discrimination occurs because of an attribute. Certainly a complaint can be made about more than one. So the Act currently covers different grounds on different occasions, and it could even be the same occasion but on more than one ground. So for example, because of age and because of sex, but not covering two or more attributes that are operating at the same time that are creating a new and distinct form of discrimination. So for example, it doesn't necessarily cover discrimination on the basis of someone being an older woman. And so we looked at different options here again and determined that the best approach was reflected in the Canadian human rights legislation, although it was already well established in case law before it was legislated there. We recommend clarifying that discrimination can be because of one or more attributes or because of the effect of a combination of attributes. In relation to reasonable accommodations, so reasonable accommodations or adjustments is a core concept in discrimination law, which requires organisations to make adjustments to accommodate people with disability in order to avoid discrimination. At the moment, it's incorporated through indirect discrimination and is also implied by exceptions to discrimination in the Act. So for example, one that is where the circumstances of impairment may cause unjustifiable hardship to an employer. So we heard from some stakeholders that rather than implied obligation as it exists under the Act, an express positive duty to make reasonable accommodations would provide clarity and give greater certainty to people with disability and duty holders. So under this approach, failure to provide reasonable accommodations in and of itself would become a contravention of the Act. It would encourage early intervention to avoid discrimination rather than waiting for it to occur, because the current framing of having an unjustifiable hardship exemption seems to support a duty holder's refusal to make accommodations. We ultimately recommended incorporating the aspect of unjustifiable hardship, which is currently an exemption, into a longer non-exhaustive list of criteria to assess whether an accommodation is reasonable. We examined many aspects of the complaints and hearing system and actually suggested reforms aimed at a number of things, increasing flexibility and efficiency, improving accessibility, and increasing access to justice. So the process in the current Act is fairly prescriptive and constrains the Commission in some ways because of the rigid procedural requirements that require basically all matters to be dealt with in a uniform way. So we recommend to reshape the process to be more flexible, responsive and tailored to the needs of the complainants and respondents who use the dispute resolution service. We recommend that access to justice be improved by a longer time frame to bring a complaint of 2 years instead of 1, allowing verbal complaints and for the Commission to provide reasonable help to people to make complaints in exceptional circumstances, and reducing barriers to people in prisons making complaints. We also recommend improvements to the current provisions for representative complaints. We heard that these provisions were cumbersome and were almost never used. We recommend aligning the approach in Queensland with criteria based on the Australian Human Rights Commission Act for federal discrimination complaints. We recommend that for only representative complaints, the complainant should have an option to refer their unresolved complaint to a relevant tribunal, so QCAT or QIRC, as a no-costs option. but with a further costs option, which would be to refer the matter to the Supreme Court. Another key development would be to allow relevant entities to bring a complaint on behalf of an affected community. At the moment, relevant entities sort of acting on behalf of a community that's affected by vilification can bring a complaint. This would simply extend it beyond vilification to discrimination as well. The idea of this is to reduce the burden on individuals who've experienced discrimination and boost the capacity to address systemic issues, and particularly those interests that might be in the public interest. So, for example, if there's a discriminatory policy that affects all people of the Sikh faith, it doesn't make sense for one person of Sikh faith to have the burden of making that complaint, but perhaps instead an organisation that represents the interests of Sikh people could make that complaint. We've got another poll open here. So the question is, which of the potential changes that I just described to the complaint process do you think is the most important? You might think none of them are important, that's okay. But if you had to pick one, so is it more flexible processes for the Commission, the option of non-written complaints, a longer time limitation, the option for organisations to make complaints, or a clearer representative complaints process?
Thanks, Heather. So those answers are coming in, and if you don't see an option there, you can also type another answer into the question box, and we can see those come through as well. So I might just give everyone another 10 or 15 seconds to pop their response in. All right, I might close up that poll now, so last chance. All right, I'll close that one down and share those responses. Okay, I'm very much with the group. I think the option for organisations to complain on behalf of affected communities, we had 32% thought that that was the most important and significant change, and I would definitely agree with that actually. And secondly, we had more flexible processes for the Commission coming in at 20%. 18% was the option of a non-written complaint, 16% thought it was important to have a longer time limitation, and only 14% thought that it was a representative complaints process was the most significant, which is really interesting. Thank you. Okay, so now we're just going to talk a bit about the burden of proof, so proving discrimination under the Anti-Discrimination Act. So at the moment, the current approach is that the onus of proof is with the complainant, except for where the respondent is proving reasonableness for indirect discrimination, or where a respondent is proving that a current exemption to discrimination applies. So we recommend a change to a shared burden of proof, which is not the same as reverse onus. I'll explain that in a bit more detail. And that would be a process of the court or the tribunal or court asking, is there a prima facie case of discrimination first? That's what the complainant would need to prove. And then the burden of proof would shift to the respondent to establish that the reason for the treatment was other than discrimination. So in summary, we heard from stakeholders that people from disadvantaged and marginalised groups were finding it very difficult to prove discrimination, and the onus of proof is a compounding factor in that. The current provisions in effect require the complainant to prove matters relating to the state of mind of the respondent in some instances, and the complainant often doesn't know what the discriminatory rationales were as part of the reason of the conduct, and that meant that often the evidence for the reason for the treatment would reside with the respondent, not the complainant. Sorry, Heather, I'm just going to jump in. It looks like the poll is just having a problem and is still showing on the screen. So I might just see if I can play around with a couple of things, but feel free to continue talking.
Okay, sure. Okay. And so one of the other issues that we heard about was, again, about the focus of case law when it came to the approach that is currently in place. So the idea is that shifting the burden from the complainant to the respondent would get to the heart of the issue quicker, rather than relying on assumptions, and so in so doing would increase the efficiency and improve transparency. Some stakeholders also thought that this sort of approach would encourage courts and tribunals to look at things such as unconscious biases, so where the respondent themselves may not have recognised or clearly articulated the reason for the treatment. Carly, I've just got something that says show my screen. Shall I be pressing that again?
Yeah, that'd be great. Thank you. I'll just see if this fixes the problem.
Okay.
Perfect. Thank you. Yes. Back
Wonderful.
to the PowerPoint.
Thank you. So we looked again at overseas jurisdictions, and a shifting or shared burden of proof is established really well in overseas equality jurisdictions, including Canada, the UK and the European Union. In contrast, we did look at the Fair Work Act, which does go further in relation to industrial matters only, where there's a reverse onus of proof. And that's where the employee would only need to establish that adverse action was taken and the employee had one of the relevant attributes, and then it's presumed it was an adverse action because of an attribute unless the employer can prove otherwise. So the difference being basically whether there needs to be a prima facie case of discrimination established by the complainant first off. We decided that on balance that the approach in the UK Equality Act, which does have that shared burden of proof, was best because it's well established with helpful case law as guidance. And it's also consistent with the approach of most other human rights jurisdictions. And we thought that a reverse onus may actually be unfair when considering the range of potential respondents who interact with the law across all of the areas of the Act, not just in the area of work. So ultimately, that's where we landed. So now I'm just going to talk a bit about the hot topic, which is positive duties, which you've probably been hearing more and more about. And so the terms of reference for this review specifically asked us to examine whether or not the law should create a positive duty on organisations to eliminate discrimination and sexual harassment. So positive duties are an increasingly common component in equality legislation across Australia. Victoria's discrimination law already includes a positive duty. There's been a review of Western Australia's equal opportunity laws, and that's been recommended and accepted by the government there. There's also 2 exposure draft bills in the ACT and the Northern Territory, which would include a positive duty to take reasonable and proportionate measures to eliminate discrimination and sexual harassment as far as possible. There's also, before Parliament, you may have heard about the Anti-Discrimination and Human Rights Legislation Amendment Bill, and that's actually already passed the lower house, and that introduces the positive duty on employers to take reasonable and proportionate measures to eliminate unlawful sex discrimination, including sexual harassment, which is an implementation of the Federal Australian Human Rights Commission's Respect at Work report. So what we ultimately recommend, I've got on the slide here, so it's a positive duty to take reasonable and proportionate measures, but it is actually scaled depending on a number of factors, and these were drawn from the Victorian legislation. So reasonable and proportionate would look at the size, the nature and circumstances of the business or operations, and any sort of practicality and cost implications. So that means that the way that a business with 2 employees may, may comply with the positive duty is entirely different from where a large company is expected to comply. So in terms of why, and thirdly, we recommend a staged implementation. This would allow time for duty holders to take steps. And when we say a staged implementation, we recommend that there are enforcement mechanisms that come along with the positive duty for the Commission, but those wouldn't come into play until for the first 2 years to ensure that there's time for duty holders to prepare. And during that time, the Commission would intend to work closely with various sectors, including the legal sector as well, on implementing the positive duty. So that's a longer period than what we had for the Human Rights Act, which in my view was a bit short. So in terms of a positive duty and why it's needed, so as I talked about at the beginning of this presentation, enforcement of the Act is currently about individuals making complaints about conduct that's already happened. So a positive duty places the burden on people who've experienced discrimination and sexual harassment to bring complaints in order to prevent future behaviour. So really, organisations aren't required to be inclusive until someone brings a complaint and can prove that they're not. So that's not necessarily, it's considered unfair by many, but it's also ineffective. So even if people do lodge complaints, and there's a lot of reasons, of course, that people don't, the capacity of a complaint to actually address broader systemic issues within an organisation is quite limited. So a positive duty is an obligation to take proactive steps to prevent discrimination and sexual harassment before it happens. We recommend that it should apply to any entity operating in an area under the Act. So that would extend to employers and schools and education providers, businesses or organisations providing goods and services, and so on. And an organisation could take active steps, for example, by familiarising itself with the Anti-Discrimination Act, ensuring leaders and managers are aware of their obligations through formal and informal education and training, developing a prevention plan based on guidance material, considering the extent to which organisational culture models respectful behaviour, reviewing internal complaints, procedures and outcomes, and monitoring and evaluating any systemic issues that arise. So as I mentioned, the types of steps that organisations would take would depend on the nature of the organisation, and we also recommend that the positive duty comes along with some enforcement mechanisms for the Commission. So we heard from our counterparts in Victoria that a positive duty, which they have had there for quite some time, but because they haven't had the accompanying enforcement powers for the Commission there, it has had a limited effect. So along with the powers, we're unsure of certainly we're not sure yet of the extent of resourcing of the Commission, and so our approach would very much depend on our capacity to engage in this proactive work, balanced with our ongoing requirements to manage complaints made to the Commission. So what we've actually recommended in terms of the enforcement mechanisms is not dissimilar to what's contained in the federal bill that I mentioned before. So it would enable the Federal Australian Human Rights Commission to monitor and assess compliance with the positive duty in the Sex Discrimination Act. And you can see I've just included on the slide a pyramid of enforcement indicating the extent to which we'd engage in various activities in our role as a Commission if we were given this role. So we anticipate a measured approach to enforcement, with the majority of the work we would do in developing and publishing guidance material and providing education and awareness raising. Less frequently, we would engage in cooperative independent reviews with organisations, usually at their request, and would also provide assistance to duty holders to develop action plans. And lastly, where there's a serious and systemic issue, we would consider commencing an own motion investigation with the options to compel attendance, write public reports, enter into enforceable undertakings with the duty holder, or take other last resort sort of actions, such as issuing compliance notices. So very much our focus would be on education first. In relation to attributes, we had a couple of tasks required by our terms of reference, and one was updating the attributes as they currently are in the Act, and then the second part was then looking at whether any new attributes needed to be introduced into the Act. For those that aren't aware, there's currently 16 protected attributes, and we were asked to look at whether they were still relevant, whether there needed to be any more, or whether any of the terminology needed to change in relation to these. So the changes were recommended, and I've got them on the slide there, were recommended, they're aimed at fixing a few different issues. So one of them is sort of the way existing attributes are defined, which has meant that people who should be protected aren't. So, for example, people are protected from discrimination on the basis of their sexuality under the current legislation, but the definition of sexuality is confined to heterosexual, homosexual or bisexual. So anyone with a sexuality outside of that list may not be protected, and that includes people who are asexual. And also in other cases, the language used to describe an attribute or its definition has meant that people don't realise they're protected, even if they are. And one good example of that is disability. It's currently called impairment discrimination under the Act. It's not necessarily how most people refer to themselves themselves in terms of disability is more common language and is reflected in UN instruments and also in federal laws. So briefly, what we recommended was that the attribute of impairment becomes disability with a new definition which is aligned with the Federal Act. The gender identity remains the name of the attribute, but the definition is updated to ensure coverage of people of various gender identities. We recommend that sexuality, the wording becomes sexual orientation, and that a new definition is included. That lawful sexual activity becomes a new attribute of sex worker with a new definition as well. That race be that the attribute of race, which is currently a non-exhaustive list, that it also includes immigration or migration status. And I know we've got a question on notice on this, about this, that I will hopefully get to later on. And finally, that family responsibilities is broadened as an attribute to become family, carer or kinship responsibility. So that recognises that that carers other than immediate family members have an important role to play, and it reflects diverse contemporary family structures and also cultural responsibilities, particularly for First Nations people. And in relation to carers, we through doing this, we would acknowledge the vital role that carers play in caring for older people or people with disability. As I said, our second task was to look, in relation to attributes, was to look at the potential for additional new attributes. We were asked to look at some particular ones by their terms of reference. We also looked at a couple more as well based on our initial discussions with stakeholders and also submissions. So ultimately, we recommend these additional attributes: sex characteristics, irrelevant criminal record, physical features, being subject to domestic or family violence, and homelessness. So we very thoughtfully considered protecting new attributes. So of course, over the last, there's been sort of no major changes in the last 20 years to attributes. There were some changes at one stage to include family responsibilities, gender identity and sexuality. But there'd been even so much change since in those last 20 years in terms of community expectations and also groups experiencing discrimination. We also did consider that we really wanted to be careful not to dilute the effectiveness of the law with a long list of attributes, particularly if there's overlap between attributes. We found that that would be particularly unhelpful, as we were hearing from duty holders, particularly such as employers and business and industry, that it's already really hard for them to follow exactly what are the list of protected attributes, and particularly where there's also differences between federal and state as well. So those were also really important considerations. And we also thought that there needed to be a clear criteria to justify the inclusion of new attributes. And so we developed a criteria for this. We asked ourselves in every case, is there a gap in protection? And also, is the proposed attribute of a comparable nature to those already covered by the Act? And so in doing so, we looked at the current attributes, which are usually based on immutable characteristics, characteristics of historically marginalised groups, or based on established human rights. So, for example, those religious belief or activity or political belief or activity attributes. So taking that into account, that's how we finally came up with the list of attributes that you see there. I'm just having a look how we're going for time. I probably won't have time to talk in much more detail at this point if we want time for questions, so I might quickly move on. In terms of exceptions to discrimination, we also had some criteria that we sort of set up when we were looking at exceptions, or rather they're called exemptions to discrimination at the moment. We suggest that the term exceptions is a better one. We've considered in relation to each exception, what was the purpose of it? What was the discrimination that was actually being permitted by having this exception in the Act? What are other jurisdictions doing? How does it interrelate with federal laws that cover the same subject matter? And then finally, the most important was the human rights consideration. So we very much used the framing of the Human Rights Act to weigh up what was the right balance between protecting people from non-discrimination, but also taking into account other legitimate purposes and protecting and balancing with other rights. So ultimately, we suggest changes, retaining, but making changes to a non-profit exemption, exceptions in relation to clubs, sport, religious bodies, superannuation and insurance, and in relation to prisoners. We do recommend that 2 exceptions were entirely removed, and that's one called work with children and one in relation to assisted reproductive technology. Both of these were fairly stigmatising and were also unnecessary or redundant. So we're going to pause again with a brief poll. So what we're hoping to hear from you about is that if these recommendations become law, what will be the single most important factor that will contribute to a successful implementation? So is it that the Commission will engage with duty holders? Is it the Commission engaging in the community with potential complainants, funding for the community legal sector, funding for courts or tribunals, or monitoring progress of reforms through an oversight committee? So I can see you're busy answering that.
Thanks, Heather. Those votes are coming through, so I would give people another 10 or 15 seconds to pop your response in, and hopefully the poll won't freeze the presentation this time around.
Okay, thanks.
All right, I might close that poll now, so and share those back with you. Hopefully you can see that on the screen there.
Wonderful. I'm pretty sure that QCAT would disagree with this outcome. So no one thought that there needed to be more funding for courts and tribunals as the main outcome, of course. We have here 33% thought that Commission engagement with potential complainants was the most important, which is great to hear. And then very close to that was engagement with duty holders, which makes a lot of sense. And then thirdly, funding for the community legal sector. Only a small number, 13%, thought that monitoring of the progress was the most important factor of all of these. That's great, thank you. I know we're running very short on time. So I guess just briefly, well, what does this all mean for you and your clients? Well, essentially the timeline isn't clear. We do know there'll be a government response by the end of the year. Because of the broad and sweeping changes necessary, we've actually recommended that a whole new act is drafted, which of course would take some time. And I'm sure that that you'll be very engaged with the process of the from there. Once there's a draft bill, of course, through the parliamentary committee process, there'll certainly be an opportunity to have further say in relation to all of these matters then. Of course, if the law does pass, then your clients, particularly if you're working on behalf of organisations who are duty holders, they will certainly need to update policies and procedures to reflect updates, including to protected attributes. And then, of course, prepare for a positive duty. And as I said, there should be a good lead-in time for that. And we certainly, as a Commission, intend to put out a lot of general guidance for duty holders with specific guidance for priority sectors in the future as well. So questions, we received a lot of questions on notice. I don't think we're going to get through all of this, but perhaps we'll just start from the beginning. Scott, I'm going to hand back over to you and we'll just see how we go.
Sure, thanks, Heather. So my question was, are there changes likely to assist employers to proactively support people with chronic and remitting conditions? And I guess the answer to that is yes. And there are 3 ways that the recommendations will do that. First is updating the attribute from impairment to disability. So using much clearer language, I think, will help. Secondly, creating a positive standalone requirement to make reasonable accommodations, I think, will have a major impact. And thirdly, the creation, as Heather mentioned, positive duty is one of the main recommendations that we're making, which would require the employer to take positive steps to prevent discrimination. So I think disability is already an area that we receive most of our complaints about, and I think these recommendations we're making will make a pretty significant difference to those outcomes. Heather, do you want me to go to the next question? Or?
That sounds good, yeah. Thanks, Scott.
Yeah, we had a question also about criminal histories. And as Heather mentioned, we've recommended that irrelevant criminal history be added as a protected attribute, and irrelevant criminal record, I should say. So this protection is already in place in the ACT, the Northern Territory and Tasmania. There is a federal protection that is unfortunately unenforceable. So there's clearly a gap in protection in this area. I think it's important to note the key word is irrelevant criminal records. So genuine occupational requirements will still be in place, and this new protected attribute wouldn't affect the blue card and yellow card systems that are in place. Before I hand it over to Heather for the rest of the questions, I did want to actually make a comment. I thought it was really interesting, that poll result on the funding for the sector. Only 20, I was amazed that only a quarter of you said that was the most important thing. But to my mind, it's extremely important that community legal centres are properly resourced to deal with discrimination matters and also Human Rights Act matters as well. So I just want you to know that it's something that I am pushing strongly as well.
That's great to hear, Scott. I'd say that we don't have everyone on the line from a community legal centre, so I bet you though that the 24% of people that voted were all CLC people.
Thanks, Carly.
Okay, we've probably got time for a couple more, so we'll keep going on through the list of questions on notice. So one person was particularly interested in complaints about housing services and housing organisations for families experiencing domestic and family violence. So certainly when recommending that new attribute of domestic and family violence, we'd actually specifically heard about unfair experiences in tenancy and housing in particular. So we anticipate it would cover, for example, situations where a violent ex-partner has caused damage to a property or otherwise negatively impacted on a person's rental history, such as where they've been required to break lease. We anticipate the introduction of this attribute would also, though, complement the changes that have already been made to the residential tenancies and rooming accommodation legislation last year, which already better support victims, survivors of domestic and family violence. We've also had a question about the reasons immigration status was not adopted as a separate attribute but subsumed into race. So it was in our terms of reference to look at as a separate attribute. That was perhaps because ACT does have it as a separate attribute, but we gave this a lot of thought, and basically based on the legislation in Queensland and the case law from interstate, we actually consider it arguable that currently race already includes immigration or migration status, because race is defined by a non-exhaustive list, which already includes fairly closely related concepts like nationality and national origin. So there didn't seem to be any good reason to create a whole separate attribute, or really any negative consequences we could think of that could flow from extending the already non-exhaustive list to make it really clear that immigration or migration status is covered by race. So we anticipate that on many occasions, so more than one aspect of race will be at play in someone's discrimination complaint. So for example, if a factory was to hire Filipino workers on a 457 visa and subject them to poorer conditions and bullying compared to the Australian-born people working there, that's probably discrimination because of their visa status, but oftentimes that'll be because of racism too. So it might be because of their national origin or ethnicity. And so those could all be argued at the same time under the umbrella of race. We might now, Carly, have we got any other questions that have come through the chat? I'm not sure I can see that.
That's right. Thanks, Heather. So there have been a couple that have come through, and I'll just remind anyone, if you do have any burning questions, you can type those into the question box on GoToWebinar now. But I do have a question from Jennifer asking if you could explain a little more about the changes as they apply to not-for-profits and clubs, for example.
Sure. Well, that was actually the subject of we did a webinar for QCOS, so they probably have a recording. I did that in a great deal of detail last week, actually. But at the moment, Queensland's been really an anomaly where all non-profits are excluded from the operation of the Act. That's not the case in the federal laws or in most other states and territories to the same extent. So we recommend that there's still an exception in place for voluntary bodies, but that's not anywhere near as broad as non-profit entities right now. So, for example, it's so broad at the moment that even the Wesley Hospital doesn't have, a complaint could not be made by a patient of the Wesley Hospital because of how broad it is. So we do recommend narrowing that, and if you just bear with me, I will bring up the recommendations. So we recommend a voluntary body exception, and that's basically where an organisation is able to discriminate in relation to members of that body, but cannot discriminate when they're providing goods and services to the public. So that recognises the importance of freedom of association as well, particularly for very small voluntary run organisations, and that would just align Queensland with what's already in the Commonwealth legislation, which would mean that a duty holder would not have the complexity of a different standard applying to them in relation to the. But as I said, QCOS webinar, which I think has been recorded, would be a great place to go to find out.
Thanks, Heather. I will see if I can chase that recording link down and distribute that together with this presentation. We've got 2 minutes left. The final question that I'll go to, and you did touch on this, Heather, in the session, was just someone requesting some more information on the vilification sort of work that is sort of happening concurrently with this review. Are you able to share where that might be found? And I can distribute that link out again with the recording for this session.
Might be best, Heather, if I respond to this one. So as you may know, that was carved out of our terms of reference, the vilification provisions, and on the basis that it was a matter that was being addressed through a parliamentary inquiry. So the Legal Affairs Committee made recommendations that the government has responded to, and there are currently discussions going on within government in relation to the implementation of the Parliamentary Committee's recommendations. I suspect some of those relate to amendments to the Criminal Code and Summary Offences Act, and they may proceed on a different time frame to those that are, require amendments to the anti-discrimination legislation, which at some point will I think be married up with the amendments that we recommended. So they're chugging along, but on slightly different railroad tracks, if you like.
Great, and I think I've found that I just popped the link into the chat, so hopefully that works for the person that was interested in that and anyone else that is keen to check it out. So that's all the questions that have come through. So we've actually finished exactly on time. So I guess Scott and Heather, if you had any final comments about this session before we bring things to a close.
I just want to say thank you, Carly. These webinars have really progressed a lot since I was in the sector, so congratulations on their development. And I just wanted to thank everyone again for the submissions that you made. We really did depend on not just the submissions about the law, but also the case studies that you provided. They were really valuable, and it shows the great value of the work that the sector does. Thank you.
Thank you very much, Scott, and thank you, Heather, for presenting today's session. I hope everyone found it helpful and a really good summary of a large report and very detailed report. So we'll be watching keenly to see what comes of this. I'll bring the session to a close now. Thank you, everyone, for completing the polls also and joining in today. Please do complete the quick survey that will pop up when the session is closed down. That's really helpful for us to continue to improve this program. And we hope to see you at the next CLCQ webinar. Thanks everyone, and bye for now.
Thank you.